Hello, I'm Marcia Banner. Welcome to this bite-sized session where I'm going to highlight 3 things that you might not have known about the residence nil rate band. The first one is that residence nil rate band can be restricted in some cases if the home passes as part of the residue of the estate and that residue is shared between a mixture of qualifying and non-qualifying beneficiaries. So, for example, we've got Jim here, who's a widower. He inherited his wife's entire estate, so he's got some transferable residence nil rate band available to him. He owns a house worth 400,000 plus 600,000 of other assets, so a total of 1 million. So that would be covered normally if he's got 2 full nil rate bands and 2 residence nil rate bands. But Jim dies in September 2023 and he leaves his estate in 2 equal parts, 50% to his children outright and the remaining 50% to a discretionary trust for his children and his grandchildren. Now, what this means as far as the residence nil rate band is concerned is that all of Jim's assets, including the home, are deemed to pass as to 50% to the discretionary trust. So that means that only £200,000 worth of value of Jim's home is actually deemed to have passed outright to his children. The other 200,000 is deemed to pass to the discretionary trust. And what that then means is he's only going to get 200,000 of residence nil rate band rather than the 350,000 that he was expecting. How can this be rectified? Can the trustees, for example, appropriate the house to the children in part satisfaction of the executors? To appropriate the house to the children in part satisfaction of their share. And we all know that executors can kind of divvy up the estate however they see fit. So if the children have a £500,000 entitlement under the terms of the will, could the executors not simply give them the £400,000 house in part satisfaction of that entitlement? Well, yes, they can, but it doesn't change the residence nil rate band position. HMRC say that a post-death appropriation doesn't change that position. So that's not going to help. Can a deed of variation be used? Well, no, not really, because what's happened here is that the share that we're wanting to put elsewhere, the share of the house that we're wanting to redirect, has actually passed to a discretionary trust. There's lots of possible beneficiaries under that trust. They'd all have to join in. You're probably going to have some that are minors, maybe some that aren't yet even born. What you can do, though, in that situation is the trustees of the discretionary trust could do a Section 144 appointment of a 200,000 or 150,000, so you get that up to 350 in total pound share of the house to the children. And that's the only way that you can rectify that position in that scenario. So that's just something to watch out for. Second one, asset protection trust, is something that I get asked about all the time. Is the residence nil rate band going to be available if the homeowner has transferred their house to an asset protection trust during their lifetime? Well, possibly and probably not. The thing with asset protection trusts is they're set up primarily, I won't put that up yet because it's too much information. They're set up primarily as a means of protecting the estate and in particular the home from claims from the local authority in the event that the settlor or the homeowner needs residential care in the future. And the idea is that they've transferred their house to this asset protection trust during their lifetime. The way the trust will usually work is that they will have a right to occupy it. And so there's no inheritance tax saving. The only potential benefit is maybe avoidance of probate, and maybe, if they're lucky, it is shielded from local authority claims. At least they don't try to attack it under the deprivation rules. The problem is that because the settlor, the homeowner, is going to want to carry on occupying this house during their lifetime, they have to have an interest in the trust. So that means it is a gift with reservation. The value of the house will carry on being in their estate for IHT purposes. However, when we start looking at whether residence nil rate band is going to be available, there's particular provisions in the Inheritance Tax Act that govern how gifts of the property where the homeowner has reserved a benefit made during lifetime are going to be treated for residence nil rate ban purposes. And what those rules essentially say is that where you've gifted your house into a trust or to another person and you've reserved a benefit, no disposal is deemed to have taken place during your lifetime. So that therefore immediately rules out any possibility of downsizing relief. Secondly, the legislation says that in this scenario, the home will only deem to have been inherited on the death of the homeowner or the original homeowner if the property originally comprised in the gift became comprised in B, that's the beneficiary's estate, on the making of the disposal. And the disposal we're talking about here is the original disposal that gave rise to the gift with reservation. Now, of course, if property is transferred to a trust during the homeowner's lifetime, it's unlikely to have become comprised in anybody's estate at the time of the transfer. The only person whose estate it's in is the original homeowner by virtue of the gift with reservation rules. Most trusts, especially if created after 2006, will be relevant property trusts. So the property won't have passed into any beneficiary's estate for IHT purposes at the time of the transfer. And therefore, no residence nil rate band is going to be available in respect of that house, despite the fact that it is nonetheless still included in the estate for the purposes of calculating the amount of IHT payable on the estate. Now, some asset protection trusts might get around this problem by including a provision that says that the home will be held on or at least a slice of the home to the value of the available residence nil rate band will be held on absolute trust for the settlor. Sometimes that works, sometimes it doesn't. It depends a lot on the drafting. And, you know, as we know, a lot of asset protection trusts, or most asset protection trusts in actual fact, are drafted by will writers, estate planners who don't understand the intricacies of the residence nil rate band legislation. And so quite often these trusts can actually create an inheritance tax problem for clients that wouldn't exist if they owned their house outside of the trust. It's always important, though, to look at the trust before making a determination, because, as I say, different trusts adopt different provisions, and sometimes they're okay, sometimes they're badly drafted and don't achieve what they're setting out to achieve. The other thing I was going to mention was the downsizing rules. The downsizing rules can be quite complicated, and this is particularly so where there's transferable residence nil rate band. And actually, in these circumstances where you have that combination of the downsizing rules and transferable nil rate band, i.e., somebody, your person whose IHT liability you're looking at calculating is widowed and their spouse left everything to them on first death, is what I'm talking about here. So they've got some transferable nil rate band and also some transferable residence nil rate band. But at some point, there's been a downsize or disposal of the main residence as well. So if you've got those two things in conjunction, the rules can appear quite complicated. I've tried to simplify them here, and I'll go through that in a second. But they can also produce quite surprising results, with actually the person ending up with more residence nil rate band than they might have had if they'd kept hold of the house. So the downsizing relief, to calculate your downsizing relief, there are a number of different steps that you have to go through. Step one is you're expressing the value of the former home at the date of disposal of that home. So when it was sold or given away, you're expressing the value of it as a percentage of the residence nil rate band that was in force at the date of the disposal, plus any brought forward residence nil rate band that is actually available to the survivor's estate at the time of their death. So by brought forward residence nil rate band, I mean the amount of transferable residence nil rate band that is actually going to be available to the survivor's estate at the time of their death based on the value of the residence nil rate band at that time. So that's step one. Step two is we express the value of the new residence, if there is any, as a percentage of the residence nil rate band allowance at the date of this person's death, again taking account of any brought forward allowance. Now this, if you've got no residence, new residence, because it was a sale rather than a downsize, this percentage this value is going to be nothing. Then on your third step, you're going to calculate the difference between your step one and step two percentages. And then your fourth step is multiply your residence nil rate band allowance at the date of death by the percentage that you've calculated at step three to give your total lost relievable amount. Now, like I said, if you've got a disposal rather than a downside, there's no new residence, you know, your step two value or percentage is going to be nothing. So the difference between your step one and step two percentages is also going to be nothing, which means that you can effectively leave out steps 2 and 3 if it's a disposal rather than a downsize. And your downsizing relief is then the lower of the loss relievable amount and the value of assets closely inherited. So I know that's all really sounds really complicated. So what I was going to do now is just show you an example of how that works in practice to sort of make that make a bit more sense. So in my example here, I've got Hilary. Now, Hilary's husband died in September 2017, and he left his entire estate to Hilary. In October 2019, Hilary sold her home for $285,000 to go into residential care. So she disposed rather than downsized. The maximum residence nil rate band in the tax year 2019-20 was $150,000. So that means that Hilary's brought forward allowance in the year of disposal was also $150,000. Hilary dies in June 2023 when the maximum residence nil rate band is $175,000. So the residence nil rate band amount at the time of Hilary's death, total taking into account her brought forward amount, is going to be $350,000. So going through those steps then, first we express the value of the former home at the date of disposal, which was $285,000, as a percentage of the residence nil rate band in force at the date of the disposal, which we've established was $150,000, plus the brought forward amount of residence nil rate band that is actually available to Hilary's estate at the time of her death. Now, because she didn't die until, when did we say, June 2023, that means that the brought forward residence nil rate band actually available to her estate at the time of her death, because her husband didn't use any of his residence nil rate band, is going to be $175,000. So if we add together then the residence nil rate band amount in force at the date of the disposal, $150,000, plus the brought forward amount of residence nil rate band actually available to Hilary's estate at the time of her death, 175,000, we get 325,000. We express the value of the former home, 285,000, as a percentage of 325,000 to give us 88%. We then express the value of the new residence as a percentage of the residence nil rate band allowance available to Hilary or potentially available to her at the date of her death. There is no residence, so as I said, this will be 0%. The difference, therefore, between percentages in steps 1 and 2 is the same as it was in step 1. Therefore, we may as well have just ignored steps 2 and 3. And we apply then that percentage to the total residence nil rate band allowance, taking into account her brought forward amount at the date of her death, to give us 88% of 350, which is giving her 308,000, which, as you can see, is a greater amount than the value of the former home at the date of the disposal. And so if her former home hadn't gone up by that amount in value, then it may have been the case that actually Hilary's estate is better off as a result of having disposed of that former home, hence the surprising result. So provided then, so the final step is, what is the actual downsizing addition available? Well, provided Hilary leaves assets worth at least that 308,000, the loss relievable amount, to her children, then that will also be the amount of downsizing addition that's available. If she leaves less than that to her children, then the amount of downsizing relief or downsizing addition, whatever you want to call it, will be capped at the value of the assets that she leaves outright to qualifying beneficiaries such as her children, grandchildren, etc. That brings me to the end of this bite-sized session on the residence nil rate band. I hope you enjoyed listening. Thank you.